Okay, so imagine an English bloke goes on holiday to the French Alps, and while he's there, he makes a snowball and throws it across into the Italian side, where it hits a German guy also on holiday. The German guy decides to sue. Which country does he bring the claim in? Have a think about that because it will become relevant in a moment. But yeah, more of that case. Okay, but we've discussed the situation, what might happen in England and Wales. But what about in other jurisdictions, specifically the United States? Well, um, let's imagine that the book repeats the allegations. I mean, very easy to actually write a book that wasn't defamatory. You could just write your entire history of everything. You could say, here's what happened in England and Wales. You could say, also, I wrote an op-ed and there was a court case and this is what happened. You could even say you were sort of quite disgruntled with it. I mean, the safest thing to ever say after a defamation loss is, I am disappointed with the verdict. Because then you're making it totally clear you don't agree with it, but you're not repeating the allegations. But yeah, so we have a trial. Depp sues for three separate alleged defamatory comments, and Amber Heard counter-claims for another three, two basically that Depp said and one on behalf of what his lawyer said, but they say you're responsible for that. We have a trial, and as we know, the jury come back and they find in favour of Depp on the three claims that he brought, which basically means the statements were false and you knew they were false, or you were reckless as to whether they were false or not. But Amber Heard does succeed on the claim against the lawyer, which Depp is responsible for. So, the situation there. We then go for an appeal. Both sides appeal their respective losses. However, the appeal is compromised. It's settled. Now, the terms of the settlement, some of it's confidential, so we'll be doing a bit of speculating. But what we do know is that they said, Depp's team said, OK, if you abandon the appeal, we'll abandon our appeal and we'll just accept $1 million instead of the 8.3 that you owe us. That in itself is quite common. Because appeals are very, very difficult to win anyway, and we discussed in other videos all the issues that, and all the hurdles that have to be overcome. But what is that? Well, again, just to clear up some misconceptions, the original verdict still stands. The appeal being abandoned doesn't do anything there. Because the appeal was abandoned, nothing's been overturned. All that's happened is somebody's agreed to take a small amount of damages. And again, that in itself isn't uncommon. I mean, litigation settles all the time at various stages, including at appeal stage. So the situation at the moment is there is a finding from a Virginia court that these allegations were false. But what if the book repeats the allegations? Well, first of all, where would Depp sue? Because this is going to become relevant. And that comes back to our sort of Alps incident with the snowball. The fact is that in that situation, you can sue anywhere. Pick any of the four countries, because it's, you can sort of go, I'll sue where I live, I'm the claimant. Actually, I'll sue where the defendant lives, make it convenient. And just as an aside, if you sue anybody, an individual in England and Wales, generally speaking, you have to sue them in their home court because, they don't choose to be sued, so why should they travel? But the main factors that come in are, where was the wrong committed and where did the consequential harm actually happen? This comes up in some criminal things, especially now we've got sort of cyber terrorism and things like that. But it used to be in the old days, when people would sort of send suspect devices across state lines and things. Do you sue somebody where they posted the exploded package, or do you sue them where it exploded, or do you prosecute them where it exploded? So this is the same sort of thing here. Where would you sue? Now, in the first trial, sued in Virginia on the grounds that that's where the headquarters of the Washington Post was. So, suing the defendant's home court, even though they weren't the defendant. But, we used to get that a lot here. We used to get what we call forum shopping. Pre-2013, there was always this idea that England was a very claimant-friendly jurisdiction for defamation. It probably was, actually, but that's very much changed post-2013. It's a very defendant-friendly jurisdiction now. But people do sort of look around and shop and, forum shop, where's the best place to bring it? Now, the general rule is that courts, like I say, they try to avoid inconsistent verdicts and decisions. So they usually say, look, if you've got, a row with somebody, pick one jurisdiction to sort this out in. We're not going to let you bring it in every single jurisdiction. So people will issue claims. Like I say, the general rule is if the claim can properly be brought in any of the courts, then it's the first one that gets it. So the first person to issue really gets to choose where it happens. But sometimes you do have these rows about what we call forum nonconwennians, to use the Latin. In other words, this isn't the suitable venue. And people say, actually, it would be better to have the trial here. Rather than there. I mean, it can be all sorts of things. It can be, this is where the harm really occurred. It could be just something like, this is where all the witnesses live, so it's just more convenient for everybody. So these are the sorts of arguments. So let's say that there is a book and Depp chooses to sue somewhere. Well, if he could sue in Virginia, that would be fantastic, because he'd just go to the Virginia courts and say, I'm suing. And there's this thing called issue estoppel. Sometimes we call it res judicata. That means it's already been ruled on. Although it's probably better to say it's issue estoppel, because it means you can't relitigate the same factual issues again and again and again. In the US, actually, they tend to call it collateral estoppel, but it's the same thing. Now, that would mean that, in Virginia, they just say, well, actually, you've already, you've had this row. And it was the same parties. Remember, we've said this only applies when it's the same parties. But they say if you're suing the same person again, they cannot start, to argue and say, well, actually, you got it wrong the first time. It's like, no, we didn't. If you had your chance to argue about the appeal that you abandoned. So that would be actually a very useful venue. But, what if Depp was to sue in some other jurisdictions? Can he then say, well, look, its issue was stopped because of what happened in Virginia? It all depends. Yes, generally speaking, US states tend to uphold the factual findings of other courts. However, that doesn't necessarily mean they follow the same law. So it could be a situation where there was a state, I think, like say Florida, for instance, say, yeah, we accept that everything was knowingly false. However, it was basically defamation by innuendo, and we don't apply that to public figures. So she can prove what she wants. So you probably wouldn't choose to sue there. Florida lawyers, please feel free to correct me in the comments about that one. So that would be a bad choice. There's also issues about limitation. Generally speaking, the limitation period for defamation in the US, it varies, but it's usually between 1 and 3 years in the different jurisdictions. Now, as I said, in England and Wales, we have this thing where repetition no longer resets the limitation clock. And I've been asking around, and there seems to be nobody's quite clear in the US as to all the states. They couldn't give me a particular list, but it may be that there are some jurisdictions that do have that rule, and others that say, no, you can sue within, limitation starts from the date of publication of the book. But there may be other states that say, well, no, because these allegations in the book, you've known about these for years, you could have sued like years ago on this. And in fact, you did, because you sued in Virginia. So therefore, we're going to say you're out, your time barred, you're out of time. But I just thought that might be just a few issues. I mean, personally, I don't think that there are going to be any cases about this. We'll have to wait and see what the book says. But generally speaking, you only sue if you can benefit from this. No competent lawyer, I think, in this particular case, because it's not, defamation is about reputation management. And if actually now you have been rehabilitated in the public's eyes, or more importantly, in the people who employ you, in their eyes, and you're not suffering any loss, why rock the boat? No competent lawyer would actually say to sue in these circumstances. And one thing we've learned from Brown Rupnick is they have very, very competent lawyers. But I just thought, anyway, that's part 2. So we've just covered everything of the case that will not go away. Let's hope it does.